Today we host Mr. Debesh Panda.
Debesh Panda. I am the advocate on record. Debesh Panda.
That Mr. Panda was at the forefront of the NN Global case and the INRIA Unstamped Arbitration case.
Of an intersection of the Stamp Act with the Arbitration Act that is taking place.
After some hearing, the court was not inclined. So the recall got dismissed. So that's the time when we decided to file a review. And luckily for us, that's when the reference order had been passed. You're just looking at the color of the money at the end of trial, but you'll see that color when you prove the facts. So unless there is something that is pressing that requires interim, if you go and ask for interim, you're not going to look good before the tribunal.
Hello and welcome to the 12th episode of the ArbCast podcast. This is a new year, and this year we intend to bring to you quality conversations in the world of arbitration, which I believe is going to be inevitable because of what is happening in the world of global trade, geopolitics, where not just commercial arbitration but also investor-state arbitration and state-to-state disputes in arbitration will play a pivotal role, which will gonna have global importance. And we're starting off the year with a bang. Today we host Mr. Debesh Panda. Debesh Panda is very well known in the profession and needs no introduction. But for formality's sake, he is an advocate on record before the Supreme Court of India and heads ADP Chambers, a boutique practice specializing in high-stakes commercial litigation and arbitration. His practice spans appearances before the Supreme Court, various high courts, international arbitral tribunals, where he regularly represents both private sector clients and government entities. He is an alumnus of the National Law School of India, University, Bangalore, and holds a master's in international dispute settlement from the prestigious MIDS course in Geneva. And I must mention, back in 2024, the base when I was thinking of starting this podcast, I was thinking, who are the people that I would like to have on down the line, and in that list you were mentioned. So it's an honor and privilege to host you today. Finally, that it has come after months of rescheduling and all that. So thank you so much.
Thank you so much, Hadid. It was a very gracious introduction, I would say. I don't know how much of it is deserved, but thank you so much.
No, it's very well deserved. I must mention also that the people that I look up to you. So it's an absolute honor. It's an absolute honor for me to do this with you on topics which are very nuanced, which I believe only someone as distinguished as you can answer. So we intend to discuss a lot of things. Starting with is the ratio on unstamped arbitration agreements in India. We know that Mr. Panda was at the forefront of the NN Global case and the INRIA Unstamped Arbitration case. And there is also an interview online by SSC online on available, where the base was mentioning about the journey of both these cases. But I think since that interview, a lot of time has went by, and then you have time to reflect upon what actually happened. So there are some more nuances that we would like to gather on those cases. My first question to you on the aspect of the INRE case is that the NN Global case was a 5-judge bench case, and you obviously disagreed with the ratio that was held in that case, which held that unstamped arbitration agreements are not legally valid and cannot be acted upon. But still, that it's a Supreme Court judgment, that too of a 5-judge bench. What gave you the confidence that we can make an appeal? One, and second, an appeal within the span of 1 year. What was motivating you to do that in the first place?
Things went slightly differently. So how it panned out in terms of timelines, a lot of it was an issue of timelines, I would say. So I got briefed in the matter after the initial judgment of the learned 3 judges that was pronounced. And my reaction when I looked at the judgment was that, okay, it's a stamping issue. You had, one view in the High Court where you felt that, the document is not exigible to stamp duty. Then the Supreme Court took a different view saying it is exigible. So what I indicated to the client was, do you want to take an attempt? We go back to the court and we indicate that, look, if this be the view, permit us to deposit that amount under protest and without prejudice to our rights, because according to me, the true character of that agreement is a matter of trial. You haven't heard the evidence, you haven't seen what the parties have to say on it. So today, on a bare bones, just a plain look of the contract, that too in an 11, I don't know if that is decisive of the matter. Also, for the reason I have personally felt, I had always had an issue with para 20 of SBP. As I said, once there's a determination made, the determination binds, which according to me was not consistent with the Act. The Act, if you see section 16, that's the only provision which has the expression rule. So the dichotomy in the Act, that what does the court do and what does the arbitrator do? When you look at it from that lens, you will see that the arbitrator is the one who's supposed to rule. This dichotomy had not really been explored either. So I think it was more of trying our best, going to court, and the client was okay with it. I said, look, I'll in fact request you to deposit the stamp duty plus the maximum penalty upfront. Deposit it under protest and without prejudice. We'll get it decided one way or the other. We did get notice on an application, in fact. It was at the peak of the pandemic. We did get notice. I did deposit that amount also in the registry. Then when the matter was being heard, and so we had not really opened it on the merits. We were purely on the narrow point, saying, allow me to then rectify it. It's a curable defect. Then after some hearing, the court was not inclined. So the recall got dismissed. So that's the time when we decided to file a review. And luckily for us, that's when the reference order had been passed by the coordinate bench, Justice Malhotra and Justice Chandrachud. So the review was primarily on the reason that how can two benches of the Supreme Court take two different views? This issue does arise squarely. And if I'm right, and let's say on the reference is answered in the affirmative, then this judgment has to be revisited. So I hadn't actually thought that far. The limited question we posed in the review was this, that look, you can't be inconsistent as a court. And keeping that in mind, the grounds were formulated purely from the angle of what the Stamp Act says, and therefore, if this question is to be considered, would the court also be pleased to consider the other connected propositions that arise? I hadn't honestly gone beyond that. The review got dismissed. In the meantime, NN Global the reference was pending. So we decided to go curative. The curative was on this limited point that, it shakes the confidence of the public in the administration of justice if on the same question there are two outcomes. And the curative was pending for a very long time. We didn't know whether it is going to get dismissed, is it going to get allowed. It was just filed and it was pending. And that's when NN Global, the 5 judges started hearing the matter. And so what we did was moved an intervention. So we didn't really have a brief except just to intervene in that matter. Judges were very kind, I would say. They at least permitted us to make submissions. And I think what we tried very hard was to make sure that we don't repeat a single line that the amicus, Gaurav sir was leading us as amicus, all the counsels. And I tried to make sure that I don't repeat a single thing that sir has urged. But we came from two completely different angles in that matter. And when you read NN Global, you will see that the dissenting minority went into great depth into this. And they did agree with us. And if you read the judgment in toto, you will see that there's a dissent by 2. Then Justice Joseph and Justice Bose had a different opinion. And then it came down to a tiebreaker of Justice Ravi Kumar. And so the tiebreak went on a different point altogether. So I think perhaps the judges must have mulled over it internally after seeing the judgment and everything. Judges perhaps were persuaded. Look, it wasn't any great shakes that we went to court and argued some great thing. This is what it was. But we were very surprised when they listed the curative in open court. They issued notice. And I had a lot of hope after that. When we prepped for the curative, I think what helped was we were led by Mr. Datar. And it it is a completely different angle when somebody who is a tax legend brings his thought process, something that we had not even factored in when we were doing before the five judges bench. And it was an amazing learning experience working with Datta sir. And so it was a blending of arbitration and stamp act. And I think what turned was Sir was extremely open to a lot of propositions. And even though that meant revisiting Supreme Court judgments, he was totally open to the idea. So I think it took a long time to narrow down what are we going to argue. And you won't believe it that the dichotomy on what is the role of a court and the role of a tribunal. And 16 is the only provision that uses the expression rule. When the matter was being argued, it fell from the bench. And we were holding that as a proposition, and I think it was Justice Chandrachud who, I think in the middle of the hearing, asked this as a question. And Mr. Datta responded, yes, that is exactly what is the next proposition before me. So it was almost like a sign. You could feel that, when you're going in the right direction, the universe conspires to tell you, what about this? What about this? What about this? I think it was also extremely enriching doing that because being nodal counsel, I was able to work with a lot of counsels who had their own perspective. And then your mind opens because you're listening to everyone. You have your brief, that's okay. That's one thing you're doing. But you're listening to so many people, everyone has something to say on this. And all of it is ultimately adding to make the discussion richer. So I remember Mr. Khambat, I had a chat with Sir also. And Sir was being briefed by one of my seniors from law school, VP. And they had a totally different angle about it. And when you look at it from that angle, then it gives rise to another set of questions in your mind. Okay, can I also try this? Can I also try this? And what happened, I think, when the hearing happened, is Mr. Datta just went about laying down the propositions, and the bench was very receptive. 7 judges were very receptive to it. There was some pushback on maybe one or two propositions. Otherwise, they were very open to examining all these questions. Mr. Khambata was exceptional, of course. Mr. Datta was exceptional. And I think that laid a very strong foundation. So we were very, very, confident. I think that's the word I would use. By the time the hearing ended before the 7 judges, I wasn't as confident when 5 ended. When 5 got over, I remember having a conversation with Gaurav sir. And I told sir that, sir, I'm not sure. My reading of the bench is I'm not that sure. I think they're on the fence. And unlike that, before the 7, I think we were all very, very, we could see that, they were open to a lot of new things coming on the table.
Yeah.
I don't think anybody had anticipated this many number of judgments getting overruled. And it's like the entire, they've painted a huge canvas in that judgment. So many things, so many facets of the Arbitration Act has been covered. That is, very grateful to the court for having, the court didn't need to. It could have focused on a narrow question and finished it off. The court made sure that it, cleared the cobwebs on a lot of issues. So that was very gratifying.
Yeah. It definitely is something that is very unprecedented. And beyond the fact that the court laid down a very extensive and comprehensive jurisprudence, what we can also see is that the accountability that they had, that look, the court has passed a judgment, but we do think there is an error, and that's how they're rectifying it within a span of one year. But you spoke about reading the bench, right? And I think this is a question which I believe only a few people can answer, which is that it is often said that in a court of law, don't ask a lawyer what will happen as an outcome, ask an astrologer, because each judge will approach a case with their own biases and own prejudices. So my question is, like, every time we approach a case, we see who is on the bench and accordingly strategize. But when we have 5 judges, there are 5 different personalities to cater to. So how do you find the balance in submitting your arguments orally in court and in ensuring that all those 5 judges are there, the way you approach that case to all those 5 judges are actually meeting the way they usually like their case to be presented? So instead of one, how do you approach it to 5 judges? Or what is the strategy behind that?
Very interesting question you asked. I think, look, first, I have only so much of experience doing this. I did the arbitration matter was 5 and 7, then we did Cox and Kings. I did the royalty batch in Supreme Court last year. That was a 9-judge bench. I think what the lesson you learn watching the greats when they're leading us, you go with the flow. You don't try to create a flow. So what happens is the part where people say it's difficult to predict a court maybe, but the fact is that's the job to do. You have a brief, they are sitting there, you have something that you need to ensure that you are able to convey to the court with clarity. So I think one thing that helps a lot is the ability to go with the flow. There will be a pushback. There is always a pushback. You can't get everything for the asking, but it's about how you navigate when there's pushback. That's what makes certain people stand out from the rest. So on an aside, I'll tell you, we were all watching when Mr. Salve had argued Vodafone 28 days in court. It was phenomenal. It was absolutely phenomenal. It's just, you wish you could record hearings, then you could keep, you only have your memory now to go back to. But at the end of the hearing, Justice Kapadia had grilled Mr. Salve. He had a lot of questions. So he was trying to do a carve out. You could see that, the judge has heard the counsel. The counsel has been extremely effective. But the judge is anxious that he doesn't want to, he doesn't want to write a judgment which will have other repercussions. So you can see that, and once you can sense that in a court, you also know that if you say this, they will say this. If they say this, then you must have an answer. You can't then, look behind and try thinking for the first time on your feet, what am I going to tell them? What that translates into is, for instance, when you see the Tiger Global judgment that came, because I'm also a standing counsel for the Income Tax Department in the Delhi High Court. We were all there when Tiger Global was argued, and we know what happened in the matter. But what we saw in Tiger Global was that counsel's forensic ability to cut through everything, strategize it in a way that he knows that now if I say this because they've said this in Vodafone, the court is going to ask me this as a question, and then I can say my facts are different. Therefore, I'm not tied down by that. That was phenomenal. Now, perhaps that is the best answer I can give to your question. When you're facing that many judges, it's a lot about being able to anticipate. It's also a lot about going with the flow. But most importantly, it's about being clear in your head that if they ask this, then this is my answer. If they ask the other thing, then this is my answer. But you stay consistent. Because the idea is not to bulldoze your way through. The idea is to make sure that the other person is convinced about what you're saying. I think that's a very subtle distinction, but that distinction makes all the difference.
Yeah, that's very interesting. But staying on the topic of strategies in arbitration, I would like to discuss some war stories with you. You have over 17 years of experience. So nowadays, in my limited experience as an intern, working at law firms and chambers, I've noticed that every time as a claimant we file a statement of claim, we also file interim measure. It's almost like a default now, like a norm that both go together. My question is that how important is an interim measure in an arbitration? Like if you win an interim measure, sometimes it can extend to the actual win itself from the arbitral award. So do you have some examples which you can cite where you have been part of an arbitration where an interim measure was just as important as an arbitral award?
So I think my answer will be, it depends on facts again. I am not a big votary of, you have your SOC and interim relief, and I don't think you can do everything, with one formula. What you have to understand basically is arbitration is versatile. Unlike a lot of other matters that you do, arbitration is very versatile. It's about how you therefore mold it, depending on what facts you have and what is the outcome that you want for your client. So let's say you have a regular case where there's a breach and there's termination, and let's say there's some damages that you're asking for. I don't know what is the interim relief you're going to ask at that stage, because you're just looking at the color of the money at the end of trial, but you'll see that color when you prove the facts. So unless there is something that is pressing that requires interim, if you go and ask for interim, you're not going to look good before the tribunal. And I've always maintained this as a counsel. The first thing that is important in any forum, arbitral tribunal, court, anywhere, you must look good, you must look credible, you must make sure that the court, whoever is hearing you, they get confidence in you. You don't get confidence if you come with run-of-the-mill things like this. Having said that, so I'll give you two examples which okay, so I'll give you an example. This is a matter, this is a reported judgment of the Delhi High Court now. So I was appearing for a Swiss entity against an Indian entity, and I'd seen the papers and I knew that therefore this is going to be tricky getting the money out. When the client sent the papers, I had only one question to ask them: why did this happen? And they actually didn't have an answer. They said, no, I know that he hasn't paid us. So I said, why is he not paying you? Have you gone deeper into it? He says, no. I said, is his financial condition bad? That's one thing I want to ask you. He says, we don't know. So I, in fact, asked them to engage somebody who's a company secretary and a chartered accountant. That person went, pulled out all the records from MCA's website, and was right there in front of us exactly what has happened. And you could actually connect the dots if you know how to read accounts, if you know how to, I mean, I'm learning, I'm a rookie on that, but you could actually see the story as it has panned out. And fortunately or unfortunately for us, just on the verge of when I was drawing up the 21 notice to send to the other side, I found out from that fellow that they're making efforts to sell an asset. And that's the trigger. So what happened was, I said, well, now if you show me that he's selling, they said, well, this is what I have to say. I said, done. We go to the High Court the next day. No 21. And we filed a 9. And the 9 was very precise. The 9, there is no room to move left, no room to move right. I mean, it was very, we had done our homework on facts. So there was very little to sort of, wiggle room for the other side, if I may use that expression. And I think what happened in the 9 was the judge understood from the 9 itself that where is this leading. So when the other side was arguing, they tried to come up with a justification for what has happened. I mean, the counsel was doing his job. He was very good senior counsel on the other side, I must say. But then that's where strategy comes in. You anticipate he's going to do something like that. So the moment he did that, I said, well, if that is your argument, you surely can't have any quarrel. If we request the High Court, since it is hearing a 9, it can include a third party. And the third party should be able to come to the court and clarify this. I'm sure you won't quarrel with that. And what that does is that gives you that upper advantage in court because you've thought it through in your head. So you're running this case. You know that, well, these are the 5 plausible things he's going to do. And in 3 out of those 5 outcomes, this is a plausible argument that you have. And it clicked instantly. So the moment I proposed it, I said, I'm sure my learned friend will not oppose this then. Why don't we get the third party in? Your lordship has the power. If this was an arbitral tribunal, I'd be in some difficulty because he's not a signatory, that third party. But you're in 9. You have all the powers. The judgments are very clear on that. And the court instantly understood where we are going because a lot of it is also about the subtext of what you're arguing. And take it, judges understand the subtext better than anybody else. So the judge also picked it up and saying, unless you oppose, then I'll have to pass an order suing this. Otherwise, we do it by consent. And so the other side understood that, okay, where is this going? They gave consent. The moment they gave consent, the third party came, filed an affidavit. That was the end of the matter. That entire thing, the entire amount got crystallized. Then there was a very small issue that went into trial. So, the majority of the real thing which we were going to fight for got crystallized in the 9 itself. So that is, and thereafter we went into arbitration. We succeeded in the arbitration also. And then 34 was filed, 37 was filed, 136, everything, all of them, we were able to navigate it through. But to cut a long story short, how this arbitration went, everything from start to finish changed because of how we had strategized the 9. So once the 9 went in and I knew that we'll get the consent, if he doesn't, then I'll press for directions to implement that third party. And the moment that happened, we knew after that where it's all going. Because there's no running away from those facts. So I don't know. I don't know if I'll call it a war story. I think what it teaches you is if you're going to be a trial lawyer, you have to learn to be strategic. Whether you're a criminal trial lawyer, whether you're a civil trial lawyer, if you learn to think, in steps, in step one, step two, step three. Okay, if this happens, then the other side will do this. If you know how to think like that, it becomes very easy. Doing good trial becomes very easy.
Mm.
I can tell you another example. I was doing a case. I am still doing that case. In fact, it was for rendition of accounts. Now, there clearly, I mean, you are saying that the other side has played a fraud. There is a need to render accounts. If you are asking for rendition, we moved a 9, showing why we are, before even initiating arbitration, we are asking for preservation and protection of the entire financial record. And the other side ended up giving an undertaking at the hearing. We'll share everything. I said, you're supposed to. The contract says you're supposed to share it. Please give that undertaking. Now, while implementing that undertaking, the other side doesn't share the complete financial record, but shares a couple of documents which completely, I didn't even know that document will exist. And once that document comes, the tribunal, and then the Section 9 court had constituted the tribunal by consent of the parties, referred us to arbitration. At that same 9 was continuing before that arbitrator as the 17. The moment the arbitrator saw those 5 documents, you can see it in the eyes of the arbitrator. Malad, this is what they've given in compliance of the undertaking. And then he says, understood, interim orders to continue, now file your claims. You can understand, see, you have to respect the fact that judges who do this, they've seen a lot. They know how to understand these situations. It's about taking it there. So if you utilize a 9 very effectively, it's half the battle won before your SOC, hits the table.
Yeah.
So,
Yeah. And the reason why I've asked you this question is because I've seen in the limited arbitration that I've worked on that after winning a Section 9 or an interim measure, the other party is more inclined to settle. And there have been cases where the other party is also settled because they feel like the other party has one up on them. But you've spoken about a very interesting aspect, which is that you filed a Section 9 and not a Section 17 because there was an issue with a third party who was not a signatory to the arbitration. So these are the aspects that we need to consider as to which forum do we go to the tribunal or to the court under 9 or 17. So my question is, under what circumstances would you say that a Section 17 is best suited for interim measure as opposed to a court? Because I would argue that a Section 9 would be more time efficient because the enforceability perhaps is easier. It's more efficient, more faster. And so that my question is, under what circumstances is a 17 better than a 9? One. Second, in your experience, how are interim measures by an arbitral tribunal being enforced by courts? Is it seamless? Is it up to the mark as it should be as compared to other jurisdictions which are pro arbitration? So if you just talk about those aspects, that would be very beneficial.
So first, the example I gave you, that was pre-Cox and Kings. Cox and Kings changes a lot of things, makes it easier to plead. In fact, now because of that ASF bill tech, even the tribunal's power to plead, that's now also very clear. So that the law is evolving very nicely in favor of arbitration. So a lot of these decisions also depend on when you are in that situation. So in that example I gave you, that was 2021, middle of the pandemic. So at that point of time, the law was different. So this worked for us. To answer your question, when will I go in a 17 vis-a-vis when will I go in a 9? It depends. First point, again, unless you have a very good reason not to wait for the constitution of the tribunal, should wait. You look like somebody who is strategically rushing to court, but take it, the judges will see through it. You don't want to be that counsel ever in court. Second, sometimes if you go in a 17 before an arbitrator who is the master of the facts, and he understands you moved a 17 and you're restricted to this point, he will also see you as, okay, I will possibly have to get into this issue. Let's see how the pleading is going to come in. It depends a lot on how the judges are. There are some judges who have been out and out trial court lawyers, or let's say on the Delhi High Court original side, thereafter, let's say, sat on the Delhi High Court original side roster for years. I mean, they just run through things very fast. There are other occasions I've appeared before judges who possibly may not have been out and out trial court lawyers or may not have sat on the original side roster of any of these presidency town courts. Their approach is a little different. I wouldn't say it is good or bad. I think it depends. Again, you have a lot of scope to play. You know exactly how the arbitrator is going to take this. So if he is going to look at it this way, give him what he wants. he will give you the outcome. If you know that, well, if you give him this, he won't give you the outcome, don't waste your time going down that route by pushing for something which you know that the judge is not going to be very open with. So yeah, I think the question of 9 versus 17 depends a lot on this. Second, having done a 17 to come back in a 9, you have to really show that it is not efficacious unless you bring in that circumstance which, creates a justification. Very difficult. One example I've done of this is we were doing an arbitration. I had a contract with someone. The contract was for construction, so and so, so and so, so and so. And the person was the owner of the property. And you knew for a fact that in the arbitral tribunal, he had indicated that I will not do this. He had given a statement, fair statement to the tribunal. Once he made that statement, I also didn't want to quarrel. I was being fair. Then I understood from the client what has happened, which is this guy was keeping his mouth shut. But there were certain arrangements he had orally entered into with the third party. The third party was now writing to the government to scuttle approvals for the project and things like that. And it was a very tricky situation, to be very honest. Luckily for us, the client was able to pull out that one document where the third party has applied to the government. One document was enough. The day he gave me the document, I said, tomorrow morning we go in a 9. 9-3, went to the court. I say, how do I now? There's a tribunal constituted. I can't make that fellow a respondent. He's not even a signatory. I need this to in aid of my arbitration. Otherwise, what's the fun of doing this arbitration if tomorrow this fellow scuttles everything sitting outside? And the court was extremely deceptive. The moment they understood what has happened, they in fact took the order of the tribunal and built upon it. So like a stepping stone. The 17 order where the statement was made was a stepping stone. Now that that statement is made, there can be no quarrel about this fact. And the source of the right of the third party was this fellow. They said, great, we'll make both of them parties and we'll pass the order. And I said, I just want a very simple order saying this till my trial, they'll hold their hands. I don't want anything more. I'm not asking for anything like the sun, moon, and the stars. I'm sure they can't quarrel with it. And what happens is, if you do this, courts are very open to it. I don't think courts will have a hesitation. So I think to come back and answer your question, it depends again on facts. You modulate depending on, what is the situation before you. And I think the most important lesson you learn when you do all this, don't play sharp. Don't try to be sharp because trust me, the person you're trying to play sharp with, he's seen this a lot more than you. But on the other hand, if he understands that you are fundamentally not a counsel who does this, if you've come and you're saying something, he's going to trust you. If he trusts you, that's more than half the battle won in court.
Yeah. So arbitration at a very fundamental level is to ensure that there is speedy disposal of commercial disputes. But that time efficiency is almost like a bargain. It should not come at the cost of the both parties not being heard. The principles of natural justice are not being followed. So it is almost like a bargain. And you have some criticisms on how there should be a distinction between domestic arbitration and international arbitration and how do we approach them. So we were having a conversation the other day where you were saying that you have a proposal to make that in institutional arbitration, domestic seated, there can be a check before the award is made to ensure that there are, if at all there are any defects during the arbitration, it can be cured before the award is made, so that the challenge cannot be made afterwards, which will save time in court and other, which is the intent of the Arbitration Act. So if you could just talk about that proposal that we were discussing the other day for our audience.
So, you'll see a lot of people who practice arbitration were also disillusioned by arbitration. And I won't name, there's a very senior law officer with whom I happen to do a few matters, and I know what Sir's opinion on this also is. We've had a very strong one-on-one conversation on this, and I know that, he has a very good reason to feel disillusioned because he has seen those same judges in court, and then he's seen those same judges in a tribunal, and he feels that, nah, this just doesn't feel right. What I feel is, you have a basic problem of accountability in arbitration. What happens is, I think section 19, in the true sense of the term, was intended to give a lot of, elbow room. It's ended up becoming a terrorist in the act. That's how I look at it. Because you have too much discretion. Every arbitrator says, "Main apne hisab se I will run the arbitration." and you don't have standardization. See, the whole rationale behind having arbitration was let's not have to follow the CPC, let's not have to follow the Evidence Act. Why did they come up with the Evidence Act and the CPC? Not for the fun of it, because they realized that if you're going to have trials run across the country, what one judge in Kanyakumari will do will be very different from one judge who in Shimla will do something else. So let's have standardization. We'll have these are the rules of the game by which everyone must play. Now, what you do is you say we'll do arbitration. But the arbitrator in Kanyakumari and the arbitrator in Shimla, they can figure out what they want to do as procedure. CPC is not binding, evidence is not binding. What that does is it leads to sometimes very unhappy outcomes. And when you practiced at least the better part of my career, whatever little work I've done in court, I've done. Otherwise, most of my work has been off court in arbitration. And what you feel is it depends a lot on where did the arbitrator train as a counsel? Was he a judge? Before that, if he was a judge, did he ever sit and do original side matters? Has he ever done cross? Has he, gone into the issues of what is the difference between an objection to admissibility of a document or objection merely as to mode of proof? Everyone has read R.V. Venkatachala, but how many people have actually done that in a trial? That's a wholly different, kettle of fish. What I feel is, and this is something I've in fact, I think there's one institution which is seriously considering it is the one my batchmate Vikas is doing it in Bangalore. That you should have a system where, as an arbitral institution, you put it down in your rules that parties shall have, and they're agreeing to this, therefore, having agreed to the rules, thing that the tribunal has done. They should come, argue it, set it right, not hold it back like a nuclear button to press at the time of 34. You see what happens, you put the 34th judge in a very difficult position otherwise. He is supposed to follow minimal judicial intervention. He therefore knows that there are nicely canalized tracks in 34. This is what he can do, the rest he can't do. A lot of these 34 judges, when they see a lot of things happen, when they see a challenge before them, they also realize this is not a happy state of affairs. But at the same time, they say, well, you made your bed, you chose arbitration, now learn to sleep in it. Even if the arbitrator goes wrong, that's fine. It leads to a lot of dissatisfaction, disillusionment. So the other day what we were speaking is there should be a mechanism by which you are able to remove, you're able to segregate a potential challenge in an arbitration or to an arbitral process from the decision itself. And on the process, if there is something that needs to be remedied, there should be an option to get it remedied in a time-bound manner so that there is one less ground to raise at the stage of 34 saying, look, the act told me wait till 34, but look, because I waited till 34, now so many things have happened. The 34 court is going to say, well, meet the threshold, else I won't interfere. It's very unhappy at that point of time. If as an arbitral institution, you are able to figure out a mechanism where you tell parties you've chosen your arbitrator. This is what he is deciding. But by rules, we shall agree that we as an arbitral institution will be able to deal with these class of challenges, let's say to the arbitral process, where one of the parties has done something, the tribunal has done something which is causing difficulty to you. We will set that right. In fact, I've had an occasion to deal with somebody who ran an institution abroad. He said, we have no problem where we tell the parties, short of the analysis in the award, till the part where the contentions are recorded, they are happy to give a skeletal copy of it to the parties saying, look, this is what the procedural history is going to record. This is what we will record as the claimant submission. This is what we'll record as the respondent submission. And these were the issues that were framed. Do you have anything to say on this? Once you tell us if you have any major reservations, we'll deal with it. Otherwise, now thereafter, the arbitrator is going to write an award. Because very often it so happened, like I tell you, I did an arbitration, the award came after a year, chunks of submissions missing. Another arbitration I did, we had a huge fight at the stage of 17, went up in 37, big question raised. There's an interesting question of law, I would say. Ultimately, the arbitrator gave a very, well-reasoned view disagreeing with me. Now, I had reservations as to whether that is correct as a matter of law. not as a matter of fact only, purely as a question of law. So when I took it up to the High Court, I said, well, this is what he has said. I am not sure if this is right, but at the end of the day, if this stands, it will prejudice me a trial. The 37 judge was also very careful to say, all right, I'm making it clear that this will not impact you at the time. He will examine everything afresh when he hears you at the stage of final hearing. But since the arbitral proceedings have traveled a certain distance since the time you began 17, I don't feel the need to get into correcting this at this stage. I said, great, that's fine. Now you come back, you see an award, one line on the entire issue. But I have argued it. I mean, I had my colleagues who were assisting me in the matter, the procedural orders record. I spent 12 hours arguing that one issue of law because we were daggers drawn on that point. I'm sorry, the act can't work like this. The act cannot take away my right like this. Please read with me. Please interpret the act. There is one line, one single line in that entire matter in the 34. Now, this is not going to make you feel good. So when you go, what are you going to tell a 34 judge? Malab, he didn't record my submission. The 34 judge is going to tell you, where have you said you didn't, where have you said you argued all this? I'll say, I put it in my written submission. He'll say, how do I know that you didn't put this in after you argued? Now imagine having something similar in a trial court scenario. The trial court judge is going to get hauled up by the district judge. There's accountability. Both the trial court judge and the district judge are accountable to the high court judges. So at the same time, if they see that something like this is happening in a formal court setup, accountability is fixed. In an arbitral proceeding, once you've done, let's say, an ad hoc arbitration, and this is what is the outcome of the process, who fixes accountability? Nothing. And there'll be one more award. What is the highest that will happen? You'll argue a 34, you'll get it knocked out. Then you're back to square one. What do you tell your client then? Obviously, the client is going to be disenchanted with the process. So what I feel is somewhere down the line, you have an act. It's a tall order to say Parliament must amend the act. That's a very big process. Jab hoga tab hoga. I mean, I don't want to get into that issue. But if people are choosing institutional arbitration, I'm sure institutions can rack their brains and offer an option to the parties saying, look, if you are choosing us, we are giving you an option to go by these rules. And in that set of rules, if either set of parties has any misgivings about the arbitral process, A, B, C, D, E topic, something, you can get that argued, we will consider it, we will decide it, and you'll come back and then you go into arbitration. It's a matter of consent. The act doesn't debar it. And what it's going to do is, it will be a circumstance that the 34 court will then bear in mind that you did have an option under the arbitral rules to avail of that remedy, saying you had a problem with this. You chose not to avail of it. You ran through an arbitral process. Now you have a finding on merits. Now at the 34th stage, why should I get into it? You need some sort of, balance to be struck. I think today the crisis that arbitration faces is a crisis of not enough accountability in an ad hoc arbitral proceeding in India. Institutional arbitration is still better, but as a country, we are primarily ad hoc arbitration driven as an entire country. So I think that's the larger issue, according to me, that confronts arbitration. Parliament jab karega tab karega. Till then, I mean, people can actually incentivize accepting rules by saying, look, in the rules, we'll give you all these options. Pick what you want. And trust me, this whole debate that has started since that PWD OM came out saying that the PWD won't participate in arbitration, give them a recourse. Make rules that give them a recourse and tell them after that, you have a recourse, why do you still not want to arbitrate? Right now, what's happening is you're not giving them a recourse. You're telling them do an arbitration. You're telling them after that you have court. These government bodies are saying, well, we don't feel comfortable arbitrating because this is not something that we are able to, accept once a verdict like this comes. I think then it's a clarion call to the entire, arbitral world. Why can't we customize and devise a solution that will attract more people to come into it? Give them that, then maybe they will do it. I think a lot of institutions in India are happy to go with what is the international norm. So they go by what CAT does, ICC does, and LCIA does. I think for India, you need slightly more desi dawai, as I say. So you should, I mean, it needs a little bit of out of the box thinking. And perhaps if you do that, the arbitral institution will actually go hand in hand with the court. The 34 judge will actually say this is good. The other thing that I feel which needs to be examined is 34.4. 34.4 in our country until Gayatri Valasamy was just Diana and IP and maybe one or two other judgments. Nothing. Nobody's really sort of given flesh and bones to 34.4. See how Singapore does 34.4. It's much, much more efficacious. That's how I would look at it. There is no reason why in India we can't give 34 for a little more teeth. What it's going to do is a party is going to be then told um, the option was a binary earlier. You go through an entire arbitral process, you pay a huge sum of money only to realize at the end of it, you are the one challenging the award saying send us back to square one. Try and use 34 for a little more creatively to maybe give a little more succor to that party which is having some, misgivings about arbitration. I think that's one thing that can be considered.
Yeah, and in your defense, I think this is not a proposal which would be more time consuming because the person is not a part of the arbitration. So it's not like you have to meet their calendars and etc. So it's not that it's going to be too time consuming also. So I have one last question, and this is the concluding question. So the majority of our audience are actually law students and young lawyers. And
Hmm.
we live in a time where, information asymmetry is less because you're watching podcasts like this. So I want to give you the opportunity to take this platform and say that the knowledge that you have now after 17 years of practice, what is that one advice that you would give to your own self when you're starting off in the profession 17 years ago, which people who are watching right now can benefit from for their careers?
I think 17 years back, if I look back at the way things have gone, I would have possibly found a little found a better way to balance time doing trial work with court work. What happens is when people come out of law school, there are broadly two schools of thought. One school of thought says, finish your LLB, then do your masters, and let's say, go to Harvard, Oxford, or wherever you're going. And then most of those people, very few of them come back to do hardcore trial work. Because a lot of trial court in India also is not a very comfortable place to begin practicing. Unless, of course, you're from Delhi or Bombay, then you have the original side here, and that makes a difference. The other school of thought is that you spend maybe 4 or 5 years practicing, then go for your masters, and then in the middle you figure out something where where do you fit? I think when I look back at my first 4 or 5 years, I started doing only trial in lower court. Then I was with the senior counsel, Mr. Ganguly. He was my guru at that time. With Sir, I did everything. I mean, I used to do Supreme Court, High Court, wherever you go. And suddenly, when I went independent, I realized that most of my work now was court, non-trial work to begin with. And then by the time it picked up enough traction where I had I had trial work again, it was a big gap. And the only trial work I was doing was in trial courts, which was very slow. Those things don't move fast enough and they don't remunerate well enough also. And it takes you away from Supreme Court, takes you away from other courts. The only thing, therefore, I would do differently if I was 17 years back was I would figure out maybe a way where I had a little more time to connect with all these things. The work I was doing at that point of time, it was a little I would say it was a little more. It was a little zigzag. Too much of zigzagging in the initial years. Um, it's good in a way. It gave me clarity. I understood what I don't want to do. I realized, and therefore there are a lot of things that I don't do now in practice because I realized I don't enjoy it very much. I would perhaps do it a little more efficiently. I think that's the only way I would look at it.
But that's a very good answer. And I think the main takeaway from not just this question, but other previous questions is that balance is key. You need to find the right balance at times. to ensure that you're doing things right. So that's
No,
it from
it's very interesting you say that because I'll tell you this. I am not the greatest person to speak about balance. At 40, I picked up income tax as a subject. I never really practiced income tax. The last year, 2 years now almost, I have been doing income tax. I love the subject. Love the subject for the reason the sheer intellectual rigor of some of the things that you have to do in that very few subjects will give you. Maybe I wish I had done this when I was 10 years younger. I would be a lot more complete as a counsel today. But the other way I look at it is maybe 2 years down the line, I'm going to pick up one more subject which I don't know anything about, and I'm going to perhaps that's the lawyer than I am. I enjoy the variety. I've seen a lot of people as they grow older, they end up focusing on only one thing and they do that. Probably that may happen, may not happen. I don't know. I enjoy the variety. I like the fact that there's something new always on the table, which I don't know. I'm happy to sit down, learn it from scratch. Arbitration allows you to do that, in fact, because one trial you do, which is oil and gas, one trial you do, which is like pure financial sector. You read balance sheets, you understand where did the money disappear.
yeah,
One you do, which is construction, you learn how do buildings get constructed and everything. I think
yeah,
that's what I enjoy more about the work I do. I mean, there's a lot of variety.
yeah. Yeah, arbitration does make you think like that because nowadays, now that I've been in this ecosystem for a good couple of years now, when I drive past a construction site, I'm probably thinking there's probably some arbitration happening in that site, and there's someone I know who's working on that case. So it makes you think. That's when you realize that this is actually your passion that you're thinking when you're not actually facing it
Yeah,
about the subject. So I
yeah.
think this is it, Debesh. I think we have discussed everything that we intended to discuss. But this is just for now. I hope we can do an in-person shoot also as we had intended to do today, but we couldn't do it for a few reasons. But
Right.
hopefully in the near future or in the future, if it interests you enough, we can have an in-person shoot on very nuanced questions of law in the space of arbitration because that is what I intend to do
I
going
don't know if
forward.
I don't know if I'll be up to the mark on that. I'll try my best. But I mean, thank you so much for your time on a Sunday morning. No, it's been very interesting. I'm happy to meet again in person. That's of course there. But questions of law, I mean, yeah, I'm happy to engage with whatever you give. Let's see if I'm able to answer them to your satisfaction. I don't know.
Yeah, time will tell. So we'll see then. Thank you so much,
Time will tell.
Dipesh. Have a great day.